Picture a married couple, paid-off house, savings, and one of them in a nursing home on Medicaid. When one of them passes away, everything they own comes down to a single question: which one died first? If the spouse in the nursing home dies first, the survivor keeps the house, the accounts, everything. But if the healthy spouse dies first, within months it is all gone, not taken by the state, handed away by their own will. The document they signed to protect each other destroyed everything instead. I call it the survivor's trap, and it hides inside a rule most couples think protects them. So let's stay with that couple, because last video I promised to show you what happens when a spouse on Medicaid passes away, and this is the version nobody plans for. As a hypothetical, call them the Halversons. He is 74 and he has been in a nursing home for 2 years. She is 72, still in the house, still sharp paying the bills. Between the paid-off house and the savings, call it $300,000 of everything they built together. When he went into the facility, they did what tens of thousands of couples do every year. They applied for Medicaid to cover the nursing home costs, because at $9,000 to $12,000 a month, their savings had a shelf life. And here is where the system actually did something decent for once. Federal law has a set of protections built specifically for this situation, and they are called the Spousal Impoverishment Rules. Long name, but the idea is simple. The government decided the healthy spouse should not be driven into poverty just because their husband or wife needs care. Medicaid has a term for her, by the way. She is the community spouse. He is the institutionalized spouse. 40 years of marriage, and the paperwork reduces you to which building you sleep in. Moving on. Under these rules, the community spouse keeps the house. As long as she is living in it, Medicaid cannot count it and cannot touch it. She keeps a protected share of their combined savings, which the rules call the Community Spouse Resource Allowance. She keeps a monthly income allowance, so the nursing home bills do not swallow the money she lives on. And I want to be fair to the system here. These protections are real, they are federal, and they work. According to Medicaid.gov, they exist in every state. The community spouse is genuinely shielded while both of them are alive. Here is the thing though. Every protection in that list has the same quiet assumption built into it. The protection flows in one direction, toward the healthy spouse. The entire system is built around one script. The sick spouse declines. The sick spouse passes first. The survivor is protected. Nobody in that system, not the caseworker, not the application, not the forms, asks the one question that decides everything. What happens if the healthy one dies first? Let's play it out the way everyone assumes it goes. As a hypothetical, Mr. Halverson passes away in the facility. The house was already hers. The protected savings were already hers. His income stops, but her survivor benefits from Social Security kick in. She keeps the larger of their 2 checks. The state paid a lot of money for his care, and in most states any claim it wants to make has to wait, because federal law blocks estate recovery while a surviving spouse is still living. So in this order, and this is worth saying clearly, the standard estate plan works. The regular will, the everything to my spouse setup that nearly every married couple in America has, does its job. She grieves, and she is financially whole. If that is how it unfolds for a family, the system worked as designed. Which is exactly why nobody sees the other version coming. Here is where it gets worse. Same couple, same paperwork, one change: she goes first. A heart attack, a fall, an accident. It happens more often than anyone plans for. Now watch what the paperwork does. Her will, the loving, responsible 20-year-old will, says everything to my husband. The house, the savings, the accounts, all of it now legally belongs to a man in a nursing home on Medicaid. And Medicaid has an asset limit. In most states, a single person on long-term care Medicaid is allowed to keep about $2,000. $2,000, that is the ceiling, the whole ceiling. The inheritance that just landed on him is $300,000. The moment those assets become his, he is no longer eligible. Medicaid stops paying, and the facility does not. The bill just changes names. $9,000 to $12,000 a month now comes straight out of everything his wife spent her life building. And it keeps coming out until the money is nearly gone, at which point he requalifies for Medicaid with almost nothing left. This is the survivor's trap. The estate does not get seized. It gets spent. Legally, automatically, exactly as their own documents instructed. Their kids watch the inheritance convert into nursing home invoices in real time, and there is nothing malicious anywhere in the chain. Every party followed the rules. Right now, some of you are already 3 steps ahead, thinking, fine, then the will just should not leave him anything. Skip him, go straight to the kids, problem solved. The state thought of that too. It is almost flattering how thoroughly they thought of that. Most states have something called an elective share, a law that says a surviving spouse has a legal right to a slice of the estate, usually a third or a half, no matter what the will says. It exists to stop people from disinheriting a husband or wife. Noble idea, wrong century for this situation. Because here is how it plays out with Medicaid in the room. If the surviving spouse on Medicaid is entitled to an elective share and does not take it, many states treat that as giving money away, a transfer, the same category as the 5-year look-back we covered last video. Declining an inheritance can trigger a penalty period where Medicaid stops paying anyway. In other words, your state may require a nursing home patient to accept money he is trying to refuse so that it can be spent on the nursing home. Somewhere, a policy manual is very proud of itself. And before anyone thinks the will is the only document in this story, here is the part that catches even the families who saw the first trap coming. Most of a couple's money does not actually pass through the will at all. The IRA, the 401k, the life insurance, the pension survivor election. Every one of those passes by beneficiary form, a piece of paper filed with the bank or the plan administrator. Most of them signed decades ago and never looked at again. The will can be a masterpiece of planning, and the beneficiary forms will cheerfully ignore it. For 401ks and pensions, that is federal law, and for IRAs, it is the contract signed at the bank. Either way, the will says one thing, the form says another, and the form wins. Every time. Now put that inside our scenario. As a hypothetical, say the Halversons fixed their wills, the trust language is in there, everything drafted properly, but her IRA still names him directly, the way it has since 1998. She passes, and that IRA does not read the beautiful new will. It transfers straight to the man in the nursing home, lands in his name, blows through the asset limit, and the trap fires anyway, through the side door. The couple did the responsible thing and updated the big document. The index card they signed at the bank during the Clinton administration outranked it. This is why attorneys who work these cases talk about the will and the beneficiary designations as one system, not two jobs. When they restructure an estate around a spouse on Medicaid, the retirement accounts and insurance policies get redirected the same way the will does, toward the trust, not toward the person. And the drafting there has its own tax landmines, which is a genuinely terrible thing to discover by accident. And one more reason this is not template territory. Here is a 2-minute version anyone can do tonight, and it costs nothing. Pull up every retirement account and life insurance policy in the house and read who the beneficiary actually is. Not who it should be, who it is. Whatever a family decides to do about it belongs in the attorney conversation. But knowing what the forms currently say is just reading your own mail. So the simple fixes both fail. Leave him everything, the estate burns. Leave him nothing, the state can force the share back into the fire. And the will alone was never the whole battlefield anyway. That is the full shape of the survivor's trap, and it is why this cannot be solved with a pen stroke on a store-bought will. Here is where it gets even more state-dependent. Because the elective share is not one law, it is 50 different laws wearing the same name. Some states set the surviving spouse's share as a flat fraction, a third of the estate, sometimes half. Others use a sliding scale where the share grows with the length of the marriage, so a 50-year marriage entitles the survivor to far more than a 5-year one. A handful of states have moved to a model that counts nearly everything the couple owned, including assets that never touch the will, while others still only reach the probate estate, which changes the entire math of what a Medicaid spouse can be forced to accept. And the community property states, places like California, Texas, and Arizona, play by a different rulebook entirely, where the surviving spouse already owns half of everything acquired during the marriage automatically, no election required. In those states, the trap has a different shape, because there is no way to draft around ownership the survivor already has. Then stack the Medicaid layer on top, because states also disagree about what happens when a spouse on Medicaid declines their share. Some treat the waiver as a disqualifying transfer aggressively and count every waived dollar. Others apply it more narrowly. A few have hardship carve-outs written into their manuals. The same couple, the same documents, the same death order can produce a protected estate in one state and a consumed one across the state line. Federalism is a beautiful thing right up until you need a nursing home. So when the next section talks about how attorneys solve this, keep in mind that the solution is not one national answer. It is a state-specific answer, which is the single biggest reason the professional doing the drafting has to practice in the state where the couple actually lives. With that said, here is the tool they reach for. Elder law attorneys solved this decades ago, and the tool has a name. It is called a testamentary trust, and in this situation, usually a specific flavor called a supplemental needs trust. Testamentary just means it is written inside the will and springs into existence at death. So instead of her will saying everything to my husband, attorneys draft it to say everything into a trust for my husband. Say it plainly. He does not inherit the money, the trust holds the money. A trustee, usually one of the kids, controls it and spends it on things that make his life better. Clothes, a better room, a companion, the things Medicaid does not cover, because he never owns it and cannot demand it. Medicaid's own rules do not count it against his $2,000 limit. Coverage continues, the estate survives, and what remains passes to the kids. And the detail that makes this work is timing, which is the same character flaw this trap always has. The will has to say this before the healthy spouse dies. A will is the one document you cannot amend from the other side. Attorneys who work in this field say the same thing about it. The couples they can help are the ones who walked in while both spouses were alive, and the elective share piece is exactly why they insist the drafting is state-specific. A supplemental needs trust that satisfies one state's elective share rules can fail another's. One more honest note. Because this channel does fair balance, not every couple needs this. If neither spouse is on Medicaid or likely to need long-term care soon, if the estate is modest, if the state is one of the light enforcement ones, the standard will may serve a family perfectly well. This tool exists for the specific situation we have been describing. One spouse on long-term care Medicaid, real assets on the table. That is the fact pattern where attorneys reach for it. So at this point it looks handled. The will gets restructured, the trust catches the inheritance, the survivor stays covered, trap disarmed. Except the survivor's trap has a second jaw, and this one closes even on couples who never touch Medicaid at all. The year after a spouse dies, the survivor files taxes alone for the first time in decades, and the tax code files them under single. Same house, similar income, half the standard deduction, and tax brackets that compress to half the width. Financial planners have a name for this. They call it the widow's penalty, and it is one of the best documented effects in retirement tax planning. A surviving spouse can pay thousands more in taxes on less income than the couple paid together, and it stacks. One Social Security check disappears. The survivor keeps the larger one, per SSA's survivor rules, but the household drops from 2 checks to 1. Then, 2 years later, Medicare looks back at the survivor's tax return, sees a high-income single filer, and raises their Medicare premiums through a surcharge system called IRMA. 2 years later, the system bills you for your grief on a delay. That is a whole video by itself, and it is exactly where we are headed next week. So here is what the picture looks like depending on where a couple stands, because this trap is entirely about timing. For couples where both spouses are healthy, the window is wide open. This is when attorneys say the documents are cheapest and easiest to fix because nothing has been triggered yet and every option is still on the table. For couples where one spouse is entering care or already on Medicaid, the window is open but it has a countdown on it, and the countdown is the healthy spouse's own lifespan, which is the one deadline nobody can see. Attorneys who handle these cases describe the same pattern over and over: the family that comes in the month after the healthy spouse's diagnosis, and the family that comes in the month after the funeral, and only one of those visits can change anything. For families already inside scenario B, where the healthy spouse has passed and the inheritance has landed, the options narrow to what state law allows: hardship provisions in some states, careful spend-down planning, and in some cases court-supervised arrangements. It is not nothing, but it is triage, and an elder law attorney is the only person who can say which doors are still open in that state. And because I know the question forming right now is, how big is this window really? Here is the honest answer about time. Nursing home stays vary enormously. Many are short rehab stints measured in weeks, but long-term stays routinely run 2, 3, 5 years and beyond, especially with dementia, where the body often stays strong long after the diagnosis. Every one of those years is a year the healthy spouse is carrying the household alone. The finances, the visits, the house, the stress. Caregiver research has documented for decades that this load carries real health consequences for the caregiver themselves, which produces the statistic nobody wants to hear but everyone in this situation should. The healthy spouse dying first is not a freak event. It is common enough that elder law practices consider it a standard planning scenario, not an exotic one. The industry did not invent testamentary trust drafting for a 1 in 1,000 edge case. The tool exists because the need keeps walking through the door. And that reframes what the window actually is. Most couples think the deadline on all this paperwork is the sick spouse's decline, because that is the visible clock on the wall. The real deadline is the invisible one, the healthy spouse's own health. which nobody is monitoring because everyone is watching the nursing home. The trap is patient precisely because it knows where everyone is looking. That is the entire argument for doing this while it feels premature. In this specific corner of planning, premature is the only time it works. Two things worth doing regardless of which group a family is in. First, Medicaid.gov has a spousal impoverishment page that lays out the federal protections, and each state publishes its own numbers. The link is on screen and in the description. Read what your state actually does. Second, the documents this video is about live in a drawer somewhere, and most were written before anyone imagined a nursing home. 1 hour with an elder law attorney in your state answers whether those documents protect the survivor or spring the trap. That hour is the entire difference between the two endings in the opening. The survivor's trap catches the exact people every protection was written for. Couples who saved, who signed the responsible documents, who did the loving thing by leaving everything to each other. The system protects the healthy spouse right up until the moment the healthy spouse is gone, and then it reads the will exactly as written. Save this video somewhere you can find it, and share it with one couple you care about. Statistically, most of the people watching this know a family standing in scenario B, and nobody has told them yet. Drop your age and state in the comments. Everyone gets read, and with elective share laws, the state matters more on this video than any I have made. If this has touched your family, if you watched an inheritance disappear into a facility, tell the story below. It is how the rest of us learn what the paperwork never says. Next week, I'm going to tell you about the letter Medicare sends 2 years after your income changes. It arrives without warning. It raises your premiums whether the income spike was a one-time event or not, and it hits surviving spouses harder than anyone. I call it the Arma bomb, and diffusing it is mostly about a single form almost nobody knows exists. I'm Mike, and I hope this video helped you in any way. Take care.